Open your cerebral cortex and shift your lobes into upper beta phase, because you are going to have Bitcoin knowledge transmitted directly into your vestibulocochlear. Your host at Bitcoin Knowledge is Trace Mayer, an early Bitcoin advocate since it cost $0.25, but this is not intended to be investment advice. A doctor of jurisprudence, but this is definitely not legal advice. And an investor in core cryptocurrency infrastructure, including Armory, BitPay, Kraken, and Mitagio, but this is not a recommendation of those services. Here, you get fed via direct mind download with pure and free Bitcoin knowledge.
Welcome back to the Bitcoin Knowledge Podcast. We've got a really kind of fun legal interview today with Jason Seibert, an attorney based in the United States. Welcome to the podcast, Jason.
Thanks for having me, Tracy. It's great.
Yeah, so it was great. You know, we spent dinner last night, watched the Tango show, and you told me the craziest yarn. So your background's data engineer for NORAD with the Air Force, went to law school, and then somehow you fell into Bitcoin. So
right place, right time.
Right place, right time. So maybe you can tell me about this case of first impression, like how you fell into Bitcoin, and then we can go from there.
So to me, Bitcoin in the fall of 2013 was a currency of choice for illicit activity. I hadn't looked into the details of it, hadn't looked into the code, really didn't understand the potential that Bitcoin had. I'd only seen the criminal activity side of it from a legal perspective. Then I had a client of mine call me up and ask me whether or not he should take Bitcoin in his store. And instead of telling him no, I said, just give me a moment and I'll call you back in a couple days and I'll look into it. So I took a look at the code and I realized what we had was a value transfer protocol to work within the structure of the internet. Finally, we basically had a money system for the internet, and I saw its potential, and no longer was Bitcoin a criminal currency, but it was a true data-based peer-to-peer value transfer protocol, and I was very excited about it. That the data geek in me just took off. So I called my client back and I said, yeah, I think you should take Bitcoin because I think it's going to be something pretty big. And as a first adopter, you would get brand loyalty, and you would be early in, and you would get the benefits of that side. So that's how I got into Bitcoin. Was a client who was curious about it. A few days later, I was watching CNN, and there was an announcement that the New York DFS was going to be holding hearings on the regulation of Bitcoin. This was early 2014. And I got on a plane that day, and we talked about it. You were there as well.
Yeah, I was actually at the same meeting. Didn't know you then.
No, we didn't meet. And we were discussing last night whether or not we thought potentially if there was an actual auger prediction market at the time, I would have put money on the Winklevoss twins being arrested because Charlie Shrem had just been arrested the day before the meeting. And so I would have lost money on that, and you would have made money on that. And that's okay. We can be wrong from time to time. That's the beauty of guessing.
Of markets.
Yeah. So shortly after that meeting, I helped draft a white paper with a friend of mine who was going to Georgetown on legal constructs and interpretation of Bitcoin within a legal and accounting perspective of how to look for that and how it really worked in the legal world, how different attorneys could raise different questions during depositions on how to cross-examine folks who may be holding assets in cryptocurrency and how they could work with estate planning on how cryptocurrency questions could be asked. Because obviously if grandpa dies with cryptocurrency keys and he doesn't share it, then all that wealth is lost. So how to really work within the cryptocurrency world. While that was happening, I was aware of the Shavers case.
And this is Trendon Shavers.
The Trendon Shavers case in Bitcoin Savings and Trust. And I represented both Trendon Shavers and Bitcoin Savings and Trust in the Sherman Division of the Federal District Court in Texas. I hadn't at that point. He'd been representing himself for almost a year, got himself backed into a corner pretty good. And I recognized that the government, the SEC, was doing some pretty good bullying at that point and using all of their tricks. And through channels, Trendon and I ended up having a conversation. And at the end of that conversation, it was decided that I would represent him and Bitcoin Savings and Trust. And so I flew out to McKinney, Texas the next day and made my appearance in the Sherman Division, and things kind of went from there. I recall my first hearing with Judge Mazant, who was the magistrate judge over the case, and he looked at me so puzzled. He was like, this case has been going on for so long, I remember him asking me, Mr. Seibert, why are you here? It's like, why weren't you here a year ago? Why are you here now? And my response to him was, Judge, before I was a lawyer, I was a data engineer, and I took care of all the mainframes at NORAD. And his face lit up. He was so happy. He leaned across the bench and he said, please, can you tell me what Bitcoin is? And I thought that was odd because nearly a year earlier, he had already ruled from the bench that Bitcoin was money. I was like, okay, so you're admitting to me you made a decision about Bitcoin being money and you have no idea what it was. And of course, I couldn't say that in open court on the record. All I could do was say, well, Judge, I'd be happy to tell you what Bitcoin is. And, you don't want to upset the judge. I probably spoke for about an hour on the record about Bitcoin being simultaneously a protocol and a brand. And the properties of value transfer protocols and how they're actually recording a transfer. It's not actually, a coined currency. That, there's no tangible asset that is
corporeal or physical.
Correct. That it's just a record of a transaction, a ledger.
Yeah. It's reality, consensus-defined reality.
And so, towards the end, we had a really good discussion, and the SEC, Securities and Exchange Commission, basically sat there with their, hands on their chins, just waiting for the opportunity to talk, because the judge and I were just having this really intense academic conversation about, life, death, big city, and Bitcoin. And, so that was my first introduction into the Bitcoin world, the legal world, was explaining to a federal magistrate judge.
And this was a case of first impression.
That's right. Case of first impression. It was the one that ultimately decided that from the Securities and Exchange Commission's jurisdictional calculation, a transaction including Bitcoin involving an investment contract for the purposes of the Howey test, Bitcoin could be money.
Right.
So narrowing that down. Of course, the IRS defines Bitcoin as a commodity. The Commodities Futures Trading Commission defines Bitcoin as a commodity. But for SEC's jurisdiction, they were able to basically backdoor legislate or backdoor rule make Bitcoin into being defined as money, regardless of a clear definition under the U.S. Code of what money is, which clearly
31 USC 5101 through 5118, right?
And cryptocurrency is not included in that.
Well, yeah, right. And constitutionally, even Federal Reserve notes aren't included in that.
Right. So we've got this. It's easier for an administrative agency to run to the courthouse to ask for law to be defined than it is to go through the notice and comment period to change rules. And so, to me, it was pretty obvious that the SEC was trying to get out in front of cryptocurrency
power grabbing
by doing this power grabbing, or under legal terms, ultra vires actions.
Mm-hmm. So, what happened with this? Shavers is backed into a corner.
Are you talking about transactionally or within
just
the
kind of procedurally,
So,
procedurally in the court? He's kind of backed into a corner.
Well, it all started about a year before I showed up. Actually, a little longer than a year before I showed up. The SEC came knocking under an administrative hat, not a civil or criminal hat, but under an administrative law hat, and they wanted him to show all of his records and all of his transactions. And Mr. Shavers very politely gave him a double-fingered salute and said, come back with a warrant, which isn't necessarily the way that the SEC wants to be received. Then, instead of getting a lawyer, he took it upon himself to represent himself during depositions.
And that's not very wise.
No, generally not. I reviewed the deposition transcripts, and it was really interesting. You can maybe those that are listening, you can find the transcript. It is available online, and then go and find some of the cryptocurrency chat logs and put them side by side and kind of read along, because the chat logs, you could see the folks were reading the deposition transcript and then commenting as they were reading it. So it's like this Mystery Science Theater 3000 kind of dialogue that's, I mean, it's in print, so you kind of have to figure it out. But some of these comments of the cryptocurrency world were just priceless, you know.
Reddit is a source of gold.
Oh, yeah. It was. So as I was preparing for the case with Mr. Shavers, obviously I needed to know what was going on in the community, how they interpreted the deposition, how he had explained himself in the deposition. Of course, I recognized that the attorneys for the SEC were doing everything they could just to keep him talking. And the idea is the more that a witness talks, the more they're going to volunteer information that's going to hurt them or potentially be used to hurt them. And Mr. Shavers didn't know that. The rule number one in a deposition is you only answer the question asked. You don't answer the question you think they ask or ask them if they ask that, because that'll just lead them to saying, well, why don't you answer that question and then we'll come back to the other one. Don't do the work of the government for them, I suppose, is the lesson there. So if you do happen to find yourself lucky enough to receive a letter from the Securities and Exchange Commission in an administrative way, give me a call.
Yeah. Well, and it might be anything, right? Because sure. If you get served even with a civil securities fraud lawsuit, it could potentially end up as an administrative law or even a criminal law action also.
That's right. The securities laws walk in three different playgrounds simultaneously: administrative, civil, and criminal. And the attorneys that are working for the government or from a plaintiff standpoint in the administrative, civil, or criminal field, they'll all share information together. So it's effectively 3 against 1. So it's really important that you protect yourself early on if you do get some form of a invitation letter to come have a discussion.
I mean, who knows with all these ICOs, these initial coin offerings and these crowdfundings, and I mean, everybody's doing all types of who knows what. And one of these bureaucrats might decide, hey, I want another pelt above the mantle.
That's right. You know, and some folks in your audience may have heard me speak in San Diego or New York or Austin, or maybe even here in Buenos Aires, which I got to tell you, I love Buenos Aires. I didn't know I'd like it so much.
Bife de chorizo.
Oh, right. It's great. Forgive me, the term that I'm looking for here is game theory strategy, right? The phrase that I'm looking for is game theory strategy. When an agency comes calling and you're trying to decide ahead of time, let me back up. You're doing an initial coin offering and you think an agency may come calling, right? And you have to decide, do I want to comply or do I want to beg for forgiveness, right? Ask for permission or beg for forgiveness. I see a lot of folks that are moving towards the beg for forgiveness route because under game theory strategy, based on the current jurisprudence, it may be financially advantageous to go out and make money under a construct knowing that you're potentially violating securities laws in order to build up a bank account large enough to be able to sustain the penalty and grow your business. That's a business decision. That's not a legal decision. As a lawyer, I can't advise anybody to knowingly violate the law. I can only present the opportunities of what may or may not happen should you make a choice. From that construct, there's also the contingent of folks within the Bitcoin world that believe that an initial coin offering is not the sale of a security because it's somehow fuel or it's a software license being sold ahead of time before the software exists to even license it. And it's those circumstances where I've told people flat out, no, that's the sale of a security. And the response from the person hearing that, the crypto anarchist or the crypto evangelist that hears that, is they want to push back and they accuse me of being a regulator. Why am I in Bitcoin? You know, why am I here? And my response to that is, I'm telling you what it is. I'm not telling you what you want to hear. I'm not telling you what you think you want to hear. I'm telling you what it is. Now, how that gets enforced later, if it gets enforced later,
at all,
if at all, is a risk-reward calculation. So this is, as I would not presume to tell a coder how to code. Don't tell a securities attorney what is and what isn't a security, okay? This is our sandbox. It's what we do. Any securities attorney that says, no, it's not a security, they're lying to you. They're only trying to get money out of you. I would rather take the approach of telling you what it is and then plan the strategies for dealing with that and how to deal with that from a risk-reward standpoint, whether or not that's asking for permission or later on begging for forgiveness. Now, how do you determine what's that line? How do I know if I'm selling fuel or if I'm selling a security? And I would just offer to the audience one question. What are you in the business of doing? Are you in the business of raising money? Or are you in the business of selling a product? So from the standpoint of, if you're truly selling fuel for a product that's operational, then you're in the business of selling a product. But if you're selling fuel to be used in a product later on that isn't developed yet, you're in the business of raising money to develop that product. Now you're selling a security. Does that make sense?
Yes, because so many of these ICOs are pie in the sky. Oh, we're going to do X, Y, Z after we've gotten your money.
Yes. And so usually what goes along with that is the person that's buying that coin offering, they're speculating.
In the scam or the pump and dump, or in the very rare case of the thing actually getting built out, right? And being a legitimate deal.
And so the regulatory agency doesn't care how you word it in your documentation, how you try to change the wording on your webpage. Oh, this is only fuel. Look, the agency have been around for a very long time. They've seen all the tricks.
They've seen all the Ponzi scams. They've seen all the fraudulent inducement.
They're not going to care how you word it. The agency there is to protect the investor, so they're going to take it from the rubric of the person handing over the money to the company. How did they view it?
And what did they expect out of this transaction?
That's exactly right. And so tread carefully, but do so in full knowledge and have a plan. That's the prudent way to go about it. Don't try to say that it's not a security. Just assume that it is, but have a plan if a regulator comes calling. Right? Don't go blindly into the future with fingers crossed, hoping that someone someday will believe your argument that it's fuel. Right?
Thanks for listening to the Bitcoin Knowledge Podcast. Our awesome audio editor needs to eat. He makes your experience better by increasing the sound quality and decreasing the show's time by editing out unnecessary ums, ahs, pauses, and such. With only a few seconds of your time, you can support the show. Do you ever buy stuff on Amazon? Before you do, simply visit bitcoin.kn/resources. You can get there from the homepage and click on one of the links. It takes you to Amazon. Then, at no additional cost to you, we get a tiny percentage of anything you purchase, even if it's not that particular item. These resources, they're all my favorite hacks that have increased my quality of life, so you might learn something helpful. They range from healthy snacks to sleep optimization, meditation tools, cognitive enhancers, immune system boosters, and much more. Maybe you'll find them useful. Either way, any support is greatly appreciated. Thanks, and now back to the show.
Yeah, so with Shavers, where did he go wrong then? Because the outcome's what, $40 million civil judgment by the SEC and an 18-month prison term?
Sentence. Yes, he's currently at summer camp at the Federal Correctional Facility.
Graduate school.
At the Federal Correctional Facility at Texarkana.
Where did he go wrong?
That's a good question. You have to recall it back in 2012, 2013. Maybe you'll remember without me giving away too much. What was one of the key functions of cryptocurrency? What did it offer a user of cryptocurrency?
Yeah, people were being able to transfer value over distance. So they were using it to speculate on things like GLBSC. They were using it to buy things, whether legitimately or illegitimately.
But it also offered anonymity.
It was not tied to somebody's identity like a PayPal account.
Right.
And so that gave it use cases with things like the Silk Road and other places.
So Shavers held on to anonymity within his transactions. So he moved in total over 700,000 Bitcoin through the Bitcoin Savings and Trust. And he never knew the actual identity of anybody he was transacting with. Imagine that for one moment. In the compliance world of know your client and anti-money laundering, do you move 700,000 Bitcoin without knowing who you're transacting with? From a risk assessment standpoint, you went to law school, you understand this. From an attorney standpoint, mitigation of risk is key. So he exchanged or lent out over 200,000 Bitcoin in a single set of transactions, a structured transaction. And he had no idea who it was that he was lending the Bitcoin to.
202,000.
202,000 Bitcoin. But it was based on trust. You may recall back then we had trust systems where people were given trust.
Web of trust.
Exactly.
And cryptographic signatures for establishing identity.
His counterparty had a very high trust rating. And they'd established a series of transactions together where they established that they had control of assets and they were who they said they were, at least within an online identity. But the actual identity of the person that he sent this Bitcoin to, he never knew for certain. So when that 200,000 Bitcoin went out and never came back, he didn't have the ability to say, hey, give me my Bitcoin back. I know who you are. And then get redress through a court of law or
for breach of contract. Or
or an international arbitral forum if the person was international.
Like Japan.
Correct. Maybe some mountain somewhere that happened to deal in magic cards at some point in time. I can't say for sure, right? There's certain things I'm allowed to talk about and not. The point being, where he went wrong was entering into that large of a transaction without knowing for certain how he could...
Who his counterparty was and how he could have redress of grievance if
how he
there was
could
breach
account
of
for
contracts.
the risk. Yeah. How to account for the risk. So that's a big risk to take. Now, when that Bitcoin didn't come back, Shavers emptied his own wallets to try to get people back as much as he could. And in doing so, he tried to do it on a fairness basis. And as a result, some brand new folks that had given Bitcoin through one of the pass-through accounts, their Bitcoin was given to some others. And it only happened once, but that was enough for the government to say, you took in somebody's Bitcoin as part of an investment and you gave it to somebody else in payment. That's a Ponzi scheme. In the loosest, most infant process terms, yes, that does qualify as a subsection of a Ponzi scheme. But generally, a Ponzi scheme is done over time.
Right. And this is just at the end, after he had a counterparty with a very large amount that defaulted.
That's right. So, I jumped in at a time when the Shavers case was under an asset freeze order, so we didn't have any ability to pay me for my services. We petitioned the court to lift that asset freeze so we could hire accountants and we could hire experts and he could pay me to continue. The court refused to lift that asset freeze order at the request of the Securities and Exchange Commission because they wanted a verified accounting of the transactions. And our response to the verified accounting request was blockchain.
You've got a record already.
Exactly. I can't give you any more verified of an accounting than the blockchain. And the SEC argued to the judge that wasn't a traditional verified accounting, that they needed something from an accounting firm, and they refused to lift the asset freeze until they had the verified accounting. So they basically created a scenario where the defendant, Shavers, was unable to defend himself. And after several years of administrative and civil litigation, my client got tired. He did. He got tired of getting beat up, and he just wanted it to be over. And his thought was, okay, we'll just try to settle. And so we entered into settlement negotiations with the SEC, but they wanted a verified accounting, and we weren't able to provide it. So settlements failed. And after that point, without the asset freeze lift and without any path to move forward to pay me. We did a Pass the Hat campaign through the Bitcoin community. Can you guys donate? We can move forward. And all told, we collected $50 because the community hated
must
shavers
not like
so
shavers.
much.
Well,
And
a lot of money.
and they didn't understand that what you had was a massive power grab by the Securities and Exchange Commission, and that's what they needed to fight. Not shavers. They needed to fight the SEC. Anyway, long story short, my client couldn't afford to pay me, and he felt bad to keep me on while I was putting expenditure out there. He finally terminated my services for inability to pay, which was unfortunate. And then shortly thereafter, the hammer fell right on top of his head. And after that, he ended up in handcuffs because of the judgment that the SEC obtained in the civil court arena. All of that went right into the Department of Justice hands, and the U.S. Attorney in New York then brought charges against him. Tying it in, of course, because they made the claim that some of the money that was transacted in order to acquire the Bitcoin from these other folks that gave shavers Bitcoin, more likely than not, entered into a New York financial bank computer. They didn't allege that any person that was harmed actually was a resident of New York. They just alleged that the money had transferred through a New York bank computer, thereby giving the Southern District of New York jurisdiction over the claim.
Were there any New York banks even running a Bitcoin full node at the time?
No, of course. Right? I mean, so the way that, and these are the tricks that they do.
Huge
These are the
power
things that they
grab
do.
in terms of personal jurisdiction
Of course.
and due process.
And they had precedent for it, so they just keep doing it. And because they deny you your ability to make a defense for yourself by freezing your assets, they just steamroll right over the top. Long story short, the defense team that was appointed to him through the public defender's office did a pretty good job of defending shavers. I had actually called up that defense team a couple of times and said, "Hey, I'm here to help if you need me," and they never called me. They had no idea what Bitcoin was, and as far as I know, I'm one of a few actual data engineers turned securities lawyer that exists on the planet.
Yeah, most lawyers studied like political science or
history,
English or
right?
something.
Yeah.
History instead of future.
So, like I said at the beginning of this talk, I found myself at a confluence of law and technology at just the right time. So Bitcoin, right? Here I am.
Here you are.
Yeah.
Well, it's been a fascinating discussion. One of the old war stories.
Yeah.
From the space, and who knows how we'll see everything else play out. Hopefully Peter Vestness of the Bitcoin Foundation will get rid of his lawsuit against Mt. Gox, and all these Bitcoins can get distributed to people as they're supposed to.
I'm sorry, I can't comment on that.
Well, I mean, just from Kraken, because Kraken's been appointed to be the bankruptcy trustee, has appointed them to distribute 202,000 Bitcoins from the Mt. Gox bankruptcy.
That's such a weird number, isn't it?
And what a coincidence. And I think Tabane the cat actually has those private keys. But anyways, the war stories. Maybe I'll have Charlie Shrim on again, or the Winklevi twins.
At different occasions, Charlie Shrem and I actually slept on the same couch in Washington, D.C.
Oh,
because we
that's
know
funny. Some of the same people down there.
Yeah.
Not at the federal pen.
No. And to reiterate, we were not on the couch at the same time.
Yeah.
Anyway.
Well, fortunately, we'll continue to be able to have financial innovation happen despite these regulators, because other jurisdictions, whether it's Europe or particularly Asia, Argentina, they are figuring it out, and it is growing super fast, and the people are making a ton of money. So, or is the U.S. just going to be this back world, third world country that can't even have clear, crisp cell phone communications and nice, clean airports like they have in China.
Yeah.
It's really kind of ridiculous.
I was shocked. The Buenos Aires airport is absolutely beautiful.
Oh, yeah.
It's absolutely beautiful.
Yeah.
Anyway.
Yeah, and fly out of LaGuardia sometime,
I've been there.
Like a dirt hellhole. But, that's what you get when you regulate stuff out of existence. You don't necessarily see what you don't have until you go somewhere else that hasn't regulated everything out of existence.
I think that's right.
And China's got a larger GDP than the U.S. now. They are full steam ahead in terms of entrepreneurship and venture capital and blockchain technology. And they're, Americans, their standard of living is just going to keep going down until they figure this out. And it's kind of unfortunate. And as that goes down, they won't have the money to pay SEC enforcement officers and stuff like that. They'll just be too poor.
Well, I don't see that in my crystal ball, but that's a
$20 trillion of debt.
Yeah.
What average net worth of an American, counting all of the debt, is negative $450,000 or something.
I don't know the number, but if that's the number, it's depressing.
It's negative hundreds and hundreds of thousands of dollars. Americans are very, very poor in terms of actual net worth. They only are able to sustain their standard of living because of a credit card. But as soon as the creditors, who are Chinese and many others around the world, decide not to extend that line of credit, then the Ponzi scam goes poof, just like Trendon's Ponzi scam went poof.
To be clear, Trendon wasn't running a Ponzi scheme.
Even if only for a minute or two.
No, that's just a light misappropriation of funds. That's not a Ponzi scheme. You might call it conversion, but it's not a Ponzi scheme. So I can try to advocate for it all I want, but your point is well taken. I think the overregulation of issues in the United States is leading to a constricted growth rate of Bitcoin technology, and that's a shame because I see more people here in Argentina. You might be able to hear them in the background if you're listening in. I see more people here innovating with this technology.
And creating value.
And advancing the technology here than I do in the United States, where they're afraid of trying to raise money to bring their idea to light because they're not sure if they're going to be regulated or not. And that kind of uncertainty creates a chilling effect on innovation, and that's unfortunate.
Yeah, I know, especially as an investor, I've refused to make any additional investments in US-based Bitcoin or blockchain companies. And one of the investments I looked at but passed on down here in Latin America, 2 years ago they had 3 employees, now they have 50.
Yeah.
And
they
got volumes that are rivaling some of my U.S. based blockchain investments that have been around since the beginning, and they pale in comparison in terms of size and success to the Chinese companies. Yeah. And so it really is unfortunate just how impossible it is to compete in this space as a U.S. person. It really is unfortunate, but that is what it is. Anyways, it's been a wonderful interview with you. We've had Jason Seibert, attorney in the United States, who represented Trendon Shavers in a case of first impression on Bitcoin and securities law. Thanks for being with us.
Hey, thanks for having me.
Be sure to get a copy of the free Bitcoin Guide at freebitcoinguide.com. Got a question or suggestion? Record your voice at bitcoin.kn. Don't be shy. To help the show, share Bitcoin.kn with friends, post about it on Reddit, and otherwise spam the interwebs. Your iTunes comments and 5-star reviews are very important to us. Please continue tuning in to the Bitcoin Knowledge Podcast, where we release interviews with the top people in the Bitcoin world. Now take some choline and let that Bitcoin knowledge consolidate.